Morning, everyone, and thank you for joining this webinar on post-permission in defending judicial review proceedings, the third in a three-part series. As most of you will know, today's seminar is what happens post-permission, i.e. leading up to final hearing. There are two previous seminars, pre-issue, pre-proceedings, and post-issue, but pre-permission online. You will get a link to all of those alongside this webinar after the event. Now, in terms of the session itself, we'll do question and answers at the end as we have with all the others. Please put Q&As in the Q&A box. You'll get the PowerPoint emailed to you after the event. With that being said, I think it's best to introduce the speakers. So most of you will probably know who I am. I'm Matthew Wyard. I'm a public law barrister at 3PB, and I'm delighted to once again be joined by my colleague, Jim Hirschmann, who I'll let introduce himself.
Thanks, Matthew. Jim Hirschmann is my name, also a barrister at 3 Paper Buildings, and my work at the moment is predominantly social care, education, public inquiries, and related JR challenges to those areas.
Thanks, Jim. One point of note before we get started with today's seminar is this seminar series was just the start of 3PB's takeover of the public law world. You'll see on the screen we are hoping to have some public law roundtable events in the near future, so stay tuned to social media and your emails for further information about those. In terms of today's agenda, there are 4 things really that we're going to be looking at. So I'm going to firstly address what happens immediately after the grant of permission, when, as those of you who have done these claims before will know, you need to make a decision as to whether you're going to settle the claim post permission being granted or fight. I'm going to deal with settlement. Jim is then going to deal with what happens if you decide to fight, and in particular the types of directions that will get enabled in order to take the case to trial. Will come back to me and I'll deal with evidence and the kind of documents that get prepared prior to the hearing, including skeleton arguments and such things. Jim will then deal with the format of the trial, remedies and costs, i.e. effectively the back final end of the process. Now, you've got the slides on the screen. I'm going to turn my video off so that you're not distracted and can see the slides in all their glory. So with that being said, let's move on then to settling the claim. As defendant representatives, you will know that the first time following your acknowledgement of service being filed that you know what's going on with the claim is when you get a permission decision land on your desk from the court. We discussed on the last occasion the types of decisions that will be made. Let's assume for the rest of this discussion that you've had a order arrive that's granted the claimant permission to proceed with their application for judicial review. With a positive permission decision, there are a few things that you need to do, and I think it's worth making a note of them now. So firstly, my view is that it's important where you're for the defendant and there is a positive grant of permission to use that as a bit of a kick to analyse your claim again holistically with reference to what's said in the permission decision. Most permission decisions, if you haven't seen one, will be relatively brief when they're granting permission. It will say something along the lines of the claimant's ground 1 has a realistic prospect of success because, and it will give a few words about why permission has been granted. That's not always the case. Sometimes a fuller analysis is given. But regardless of what is said, it's important to view what's said in the context of your claim and think about next steps. Do you, based on what's been said, need to think about amending your claim? Have the facts that have given rise to the claim moved on, i.e. is it a rolling judicial review? And do you therefore need to amend your claim for those reasons? So that's point number 1. The other 2 key points when you get a positive permission decision are obviously to note down any deadlines that are given. There are standard directions in most judicial review claims, and Jim will explain those shortly. But it's not always the case, particularly in things like urgent cases. The court can expedite the timetable and often will, or in any event, it occasionally makes other directions. Importantly, as with any court order, note down any deadlines and make moves to follow any directions that are set. As well as deadlines, then, the other key consideration following a positive permission decision is next steps. And I've touched briefly on whether you need to amend your claim, and that's relevant if you want to fight. And lots of people do fight claims, regardless of a positive permission decision being made. But the other option, and the option that I'm going to touch on now before handing over to Jim, is what happens if you decide fighting is too risky and you want to settle your claim. Now, it might sound slightly odd if you're unfamiliar with the area to say, well, why on earth would we incur fees fighting permission only to then concede if permission is granted? Well, I would offer 3 reasons and 1 tactical consideration as to why you might want to do that. The 3 reasons why you might want to settle a judicial review post-permission are not necessarily dissimilar to those considerations that run throughout any civil claim. You know, if the claimant has got past permission, that there is at least an arguable ground of judicial review there. So that should help focus your mind. If you settle the claim, as with any other claim, you limit your cost risk. Claimant will probably want their costs of obtaining permission, but you're not going to have potentially the enormous costs that you would incur going to trial. You, as a defendant, maintain a real element of control over the outcome, because many public law settlements do not necessarily result in injunctions, prohibition orders, etc. being made against defendants. The vast majority of them don't. But thirdly, and what can be important, particularly for things like local authorities, are that you've been seen to take the opportunity to fight permission. You've not just rolled over, particularly with regulators, local authorities who get challenged very, very frequently. You don't necessarily want to be seen as rolling over at the first opportunity, i.e. you've received a pre-action letter, or you've had a claim being issued, or we're going to concede everything. Having a grant of permission made is a natural opportunity and the natural time for you to concede a case if you're going to, and you don't want to concede at the outset. Those are the 3 main reasons people tend to settle public law claims post-permission, but I would also offer a 4th point, which is more of a tactical point. We touched in another talk on the fact that where a claim is entirely academic, the court will either usually not grant permission or occasionally will grant permission, but it comes into play at the remedy stage, and Jim will touch on this later. If, following a grant of permission, you can make an open offer of settlement that effectively renders the claim academic, then that places the risk firmly in the claimant's hand as to whether or not they wish to proceed with their judicial review challenge. Had a very, very good example of that this week, in fact, not in the judicial review context. It's a Court of Appeal case that I'm dealing with, where, as the defendant, we wrote to the claimants with an open offer of settlement saying, effectively, we're willing to review our earlier decision. That's more than you'll get if you succeed in the Court of Appeal, which will just remit the matter back to the upper tribunal. Therefore, take our offer. Otherwise, we're going to be writing to the court, noting we've made an open offer, inviting it to find that your claim's academic and determine the appeal on the papers. There are some differences with how you would have to do that in a judicial review claim procedurally, but the point remains that if you can effectively render the claim academic through an open offer, then that is extremely beneficial when the court looks at remedying costs should a claimant be unwise enough to continue their claim. So you've conducted your analysis of the permission decision, you've had the awkward discussion with your clients, and they've advised you or instructed you that they want to settle the claim. What do you need to do practically in order to make that settlement happen? Well, Practice Direction 54A, paragraph 16.1, gives the details of what should happen. It's in relation to what should happen where it's phrased as an agreed final order, because as with most civil litigation, when you are settling the claim, you need to file the order with the court. What paragraph 16.1 requires is 3 things, in theory, to be filed. Usually it's only 2. Firstly, the draft order. Secondly, a statement justifying the settlement. And thirdly, although I would suggest rarely, and certainly I've never seen it, any authorities that are being relied upon in order to facilitate settlement. Now, the order and the statement both require counter-signatures by both parties, and it's important that you file 3 copies with the Administrative Court Office. And I'll come on to the order and the statement and what needs to be contained in them momentarily, but what I would flag up at the outset is that it's really important that you get this right. I had a hearing fairly recently in the King's Bench Division for the defendant where a case had settled. We had spent a long time working on the order, the statement justifying the settlement, and because of one very, very minor error in the heading of the statement justifying the settlement, the court didn't approve the order and hauled everyone in for a hearing. Now, thankfully, the error in the document was not my fault. I suspect if it was, we may have had a cost order against us, but in this case, we managed to everyone agree to bear their own costs. But the court does not give you much of a pointer as to what you've done wrong or what it's unhappy with. It will simply call you in for a hearing. And I would suggest that the closer to a hearing that settlement is made, the more likely that is to happen. There were various factors in my case. It was on the Friday before the hearing was due to be heard on the Monday. There'd been some back and forth between my solicitors and the court. I found out about it on the Friday, spent the day trying to resolve the matter, and at 4:30 then got the notification from the court that the court was not satisfied with what was being done and it was calling the parties in for the hearing. Now, thankfully, the hearing was fairly quick. We walked in, High Court judge appears, tells everyone off and says, this is what you need to do, these are your options, and we managed to resolve it fairly quickly. The reason I flag it is that just make sure you get it right. Don't be in the position where you're called in. With that word of warning echoing in your minds, what then should be in the settlement documents? There's very little by way of information as to what the court expects in these documents. In the procedure rules, there is some in the admin court guide, and I've put the key things raised in the administrative court guide on the slide. So you need to obviously say it's a consent order. It needs to be signed. It needs to outline the manner of determination of the claim, i.e., has the defendant agreed to review its decision? Is a decision being quashed? And you also need to have the provision for determining costs. Those are the 4 things that it must contain, but besides that, you've got pretty much free rein on what goes in the order. It's not usually, in my experience, the order that causes the problems. What does cause the problem is the statement justifying the settlement. There is no guidance given on what that should contain. My experience, having done at least 2 in the last 3 months, and having done more, considerably more over the last year, is that keep them brief and to the point. They don't need to be lengthy documents. If it's the claimant drafting it, then you need to look at it carefully as a defendant, because what you'll find a lot of claimant lawyers will do is use this as an opportunity to flag up all their arguments and try to slip in things that suggest that you've acted unlawfully, which is not necessarily in the spirit of settlement. So when you review it, make sure it's brief, make sure it's to the point, make sure it outlines any relevant facts and the procedure by which you've arrived at the settlement, and then very, very briefly set out why settlement is appropriate and why, importantly, the specific terms of settlement are appropriate. Lawyers love to say things need to be concise, brief, and to the point. In practice, often it doesn't happen. To flag up my experience of it from the 2 that I've done very recently, both documents were a page long. You do not need to file lengthy statements. You just need to say what's happened and why settlement is appropriate. And if you do that, then in theory, you should be okay. You can, and there's nothing necessarily wrong with identifying this error of law has occurred if you think as a defendant it's fair to do so. But that's only if it's appropriate. You don't always need to. Settlement is settlement. It's not designed necessarily to blame one party or the other. So just think carefully before you agree things in these settlement documents. Now, as I've said, if you don't settle, your other option post-permission is to fight. And the court will either make directions or will outline that the CPR standard directions are to be followed. So on that note, I'm going to hand over to Jim, who's going to take you through the types of directions that there are.
Thank you very much, Matthew. So in circumstances where you've decided to fight it, you haven't rolled over, you haven't settled, then the next stage is for you to get directions from the court. So if we go on to the next slide. So the starting point is when granting permission, a judge will generally give consideration to three matters. First, deadlines for detailed grounds of resistance and any pertinent evidence. What level of judge should hear the case? Is it going to be a deputy high court judge, for example, or will it be the divisional court sitting with two or more judges? Other matters such as skeleton arguments, trial bundles, or authority bundles. As Matt mentioned earlier, if it's going to be an expedited case, it's more likely that you'll get bespoke directions. Otherwise, I'd normally expect standard directions to apply. And I set those out on the next slide. So I should make reference here to the Administrative Court Guide 2022, paragraph 10.1.4. It's an invaluable resource to use for information about how the admin court conducts its business. So I'm going to take you through, I think, 8 points in relation to this and what standard directions you should be aware of. And it's important to have these in mind because it will be relevant to planning your workflow, your capacity, and importantly, capacity for counsel if you want to retain them. And you might want to get your instructions in early if you want them to settle some of the documents for the claim. So first of all, the relevant fee for judicial review. If you don't pay it as the claimant, within 7 days of permission being granted, you'll get an angry letter from the admin court office, and that will warn you that if you don't pay it within a further 7 days, then the claim will be automatically struck out. So for claimants, be very careful to pay the costs. Second of all, any party who wishes to contest or support the claim needs to file and serve the detailed grounds and any written evidence or documents not already filed in a paginated and indexed bundle. And you've got 30 days of permission to do that. Be wary of the page count limits. Detailed grounds should be concise, must not exceed 40 pages without the court's permission. If the claimant does exceed 40 pages, that is not an excuse for the defendant's grounds to exceed 40 pages. So keep that limit in mind. Keep in mind the 35 days in which to prepare them. It will often be the case that you've got very limited information before the court up to permission. And if there's anything you want before the court, you really do need to make sure to get it in promptly to avoid falling foul of the court later on. Having said that, point 3, if you have managed to put everything into your summary grounds, if all the relevant evidence is before the court, then you might not want to file separate detailed grounds, but just indicate to the court that the summary grounds are to stand as detailed grounds. With that in mind, you need to think about the duty of candor and cooperation with the court. It's particularly important in judicial review to make sure that all the cards of relevant information are before the court. And if you think something's missing, it's a very good idea, I'd say essential, to file further supplementary grounds setting out that information. So in terms of the fourth point then, skeleton arguments, so you've got all the evidence before the court, and that's 21 days before the substantive hearing. Again, be aware of the page limit for skeleton arguments, and that 21 days refers to calendar days. In relation to representations at substantive hearing from a defendant, again, you've got 14 days. So that's a pretty tight turnaround. You've got 7 days to consider the claimant skeleton and to get the response in. Then in terms of the paginated bundle, that needs to be agreed. So again, cooperation between the solicitors is important in this regard, or there's going to be a risk of real delay in getting that agreed bundle together. Particularly important if you're a defendant and that's a litigant in person. I suggest you give yourself some wriggle room to agree that by starting early. And that's due with the claimant skeleton. Then the authority bundle needs to be lodged with the court not less than 7 days before the hearing. And that's got to include both the claimant and the defendant's authorities. And if it's a divisional court case, then you should provide one set of the bundle for each judge in the case. So those are the standard directions. I'm going to pass back on to Matt, but I hope that's helpful in terms of workflow. And when you get the slides, you'll have reference to them as well. And of course, reference to the admin court guide.
Brilliant. Thank you, Jim. That was really, really useful. We'll now look at some of those that you've flagged up in slightly more detail. So firstly, the detailed grounds of resistance. Jim has helpfully addressed on his slides all of these dates, but I put them on as a reminder, really. So 35 days if you want to contest your claim or contest it on different grounds to those that you've raised at permission, although note that if you decide to stick in different grounds in your detailed grounds of resistance to those you relied on in your summary grounds, and that is then the reason why you are successful, there is a cost risk to you there, because the court is potentially quite rightly likely to turn around and say, well, why the hell didn't you put them in your summary grounds? So if you are changing your grounds at the detailed grounds of resistance stage, make sure you have a good justification that you can rely on as to why. As Jim has said, if you've done a fairly thorough job on your summary grounds of resistance, then you can tell the court that they're going to stand as your detailed grounds. Before I move on to evidence, one point that Jim did raise that I think is really useful to remind yourself as a defendant lawyer, and I say this as someone who used to, before they were at 3PB, worked in-house at a claimant public law firm, doing a lot of judicial review work. Claimants do forget that they have to pay the court fee. It happens semi-frequently. There is no harm as a defendant calling the court and saying, it's been a week since we got served a permission order. Do you know, can you tell us if the claimant has paid the fee? Because the problem is, if the claimant hasn't paid the fee, Jim's right, the court will send a letter out. It doesn't just strike out your claim straight away, although some believe it does. It does give you a second opportunity, and it will send the claimant a letter. But as with all courts, the admin court has delays, and if you want to remind the court to get on with it, there's no harm in prompting them to do so. That certainly helps focus the claimant's mind as well. When they get a letter come through saying you haven't paid the court fee, it certainly makes the lawyers sit up anyway. So, evidence. How are you going to win or lose your case? Importantly, in judicial review, no evidence can be relied upon unless it's been served in accordance with Part 54 of the CPR or a court order, or alternatively, you've made an application to rely on evidence and the court has granted permission. The usual time for defendants to file evidence is alongside their detailed grounds of resistance. And when you do so, as Jim has said, you have to file it in a paginated and indexed bundle. It needs to be filed in both a hard copy and a soft copy as well. It's important that that's borne in mind. Now, one of the big differences that you'll see if you've attended a judicial review final hearing, as opposed to any other type of civil claim, is evidence. Most civil trials, you turn up, maybe there's an opening speech from counsel, maybe there isn't, and you just crack on with the evidence. But witnesses will turn up, witness statement will be adduced as evidence, and they'll be cross-examined, re-examined, etc. That does not happen in judicial review, or at least the default position is that it doesn't happen. Evidence in judicial review claims is 95% of the time solely written. There are circumstances, however, where you can have live evidence and cross-examination in judicial review, although you have to seek that by way of an application under Part 8 of the Civil Procedure Rules. And if you want the full reference, it's paragraph 8.62. You have to make that application promptly, and importantly, because it's slightly different in normal Part 8 claims with judicial review, you have to explain why, in the context of a judicial review claim, live evidence is necessary for the fair determination of the claim. Now, I cannot recall having done a judicial review final hearing where you have live witness evidence. I know a couple of people who have done, and it's always been in the context of things like immigration. I know one who's done an education hearing where it was the case. It's usually, as most people will know, judicial review is not the remedy for you if you have massive factual disputes. If there is one or two minor disputes, but those disputes are crucial for the outcome of the claim, you can have live evidence and cross-examination. As I say, typically it's things like immigration or Human Rights Act claims where you do have it. When you make your written evidence, or when you take your witness statement, I should say, there is no limit on the amount of evidence that you can put in your witness statement. It doesn't have things like page counts, etc., like it does for the detailed grounds of resistance. But it's important to bear in mind that the only evidence going in those witness statements should be that that's relevant. There shouldn't be legal arguments in the witness statements, but you also need to bear in mind your duty of candor when you're producing the witness statements for your clients. So yes, you're going to take the primary evidence, proof of evidence from your clients before it's typed up into a witness statement. Make sure, where the duty of candor is concerned, you get all the information you need from your client before you type it up. There's nothing worse and nothing more time delaying for solicitors in producing a witness statement, sending it to your client, only for them to come back with either a lot of amendments themselves, or you've had to go to them with 1,000,001 questions and they then come back, answer them, and you have to redraft the witness statement. In terms of the types of people giving the evidence, you probably want your key decision maker. I say probably, you definitely want your key decision maker as the primary witness statement. And they need to explain, I would suggest, in detail and with reference to documents, meetings, etc., how the decision was made. If you go back to presentation 1, where we outline some of the key principles to good public law decision making, so taking into account relevant considerations, giving reasons, etc., that is the type of thing that you ideally want your witness to be talking about if you are to succeed in demonstrating that you've made a lawful decision. A decision maker should be able to explain, with reference to the factors they've considered, why they reached the decision that they did. And that is the kind of narrative that you need in a witness statement. You don't need legal arguments to be made. Leave that for counsel at trial and focus on the issues. Bundles in judicial review hearings can be very small, so it really is important that you get the witness statements right. That being said, I do remember there's a case called Zahid in the University of Manchester that I was heavily involved with, where 3 files arrived at the court for the bundle. The judge was not necessarily too happy with that, so make sure that you only include relevant information in your exhibits as well. One thing I haven't put on the slide, but it's important to bear in mind, is expert evidence. That is not usually required in judicial review, you would need permission to rely on it. The kind of circumstances I've seen where it has been allowed in judicial review claims, really there are two. One, which is when there's a Human Rights Act element to the challenge, because you can have, it is perfectly acceptable to have expert evidence to deal with the proportionality of any decision that's been taken in a human rights context. And also things like public sector equality or discrimination type challenges. You can potentially have expert evidence involved as well. But the default position is you won't get it. So be careful before you start making applications. Alongside evidence, another key document that goes before the court is the skeleton argument, typically settled by counsel. I've given you the deadlines on the slides. Make sure you comply with them, or make sure your counsel complies with them if you're instructing counsel to do one, because if they don't comply with the various CPR requirements of a skeleton argument, it can result in the skeleton being returned to the author and the costs of preparing it disallowed. I have personally never known that to happen, and I've seen plenty of skeleton arguments that don't necessarily comply to the rule of the CPR, but it's your client, and my view is it's not worth taking a risk even if other people aren't following the rules. So what are the requirements that you need to follow? Well, firstly, it needs to be concise. It mustn't exceed 25 pages without the court's permission. That's pretty self-explanatory. It should define and confine the areas of controversy. I always take that to mean define what the issues that the court needs to decide and explain your case on them. Typically, I flag up the issues in the introduction, but other people do it differently, and there are various ways to do it. They must be self-contained. This is an important one. What the admin court judges really don't like is when you file a skeleton argument and you have your heading factual background and you say, please see paragraphs 2 to 42 of the detailed grounds of resistance on page X of the bundle. That has now been put in the CPR as being something that you simply shouldn't do. You need to set out everything that you want to rely on in your skeleton argument itself. It shouldn't refer to other documents. The other thing judges don't like is extensive quotations, either from authorities or evidence. This is now on a footing in the CPR as well. So authorities must state the proposition of law that the authority demonstrates, give the name of the authority, and importantly, identify which paragraph in the authority the proposition of law comes from. You don't need to quote from the paragraph. Just say the proposition of law that's being relied upon, the case and the paragraph. Equally, I haven't put it on the slide, but the same thing goes for evidence. You don't need to quote extensively, particularly from the decision under scrutiny. The judge will have read the bundle. They don't need to read the contents of the key documents twice. Just flag up the document and the relevant paragraph and check that that's what your counsel is doing as well. In terms of structure, this is more for people who may be watching who haven't necessarily been involved in these types of claims before. Skeleton arguments tend to be relatively formulaic. In judicial review claims, there's no problem. You don't need to fix it. You'll find that someone will give a list of essential reading. We'll come on to that shortly, because that's important in another context as well. And then typically there'll be an introductory summary, the law, the facts, submissions on the issues. There will usually be submissions on remedy, because as a defendant, typically you will say, well, even if we're wrong about how we've defended the claim, then the claimant still shouldn't get the remedy they're asking for because X, Y, and Z. And then you'll have your conclusion and it will be signed off. Now, alongside skeleton arguments, with the amendments to Part 54 of the CPR over the last couple of years, there are now more documents that have to be prepared and filed before the final hearing. An agreed list of issues, an agreed chronology with page references, and a list of essential reading alongside a time estimate for that reading. Now, the big flag in the rules is that the issues and the chronology must be described neutrally. It's not an opportunity for lawyers to attempt to persuade the judge one way or the other. They need to be done neutrally. Now, usually, my experience is it is counsel who will prepare the list of issues, the chronology, and the list of essential reading. But that being said, you don't have to be reliant on counsel to do that. You can do them yourselves. And if you want to, the most straightforward way to do it is this. List of essential reading will already be on the skeleton arguments that have been filed, so you can take those off the skeleton arguments. The issues, while you're the lawyer who's had conduct of the case, you can probably do a fairly good draft of what the list of issues are, and the chronology is usually set out pretty well in the skeleton arguments. So that, in a nutshell, if you want to do it yourself, is how you would do it. Time estimates are interesting. If you want a formula to work out time estimates, the way I tend to think about it is that the average person can probably read 70 to 80 pages an hour. A judge is probably a bit cleverer than the average person, so they can probably read 60 pages an hour. If you work out how many pages are in your list of essential reading and work out that they will probably get through 60 an hour, then you can probably have a very, very good guess at what the time estimate for reading the documents is going to be. In terms of bundles then, as Jim has flagged up, there are ultimately two types of bundles in a judicial review claim. The hearing bundle, i.e. the bundle with the pleadings and the evidence in, and the authorities bundle. Now, if your hearing bundle is going to be over 400 pages, then you have to produce a core bundle and a supplementary bundle. The core bundle must be agreed, as must the supplementary bundle, and it must include the pleadings, the decision under challenge, and any other essential documents. And if you are going to prepare a core bundle, then, or in any event, you have to certify as the solicitor now that the hearing bundle meets the requirements of Practice Direction 54A. There's no special format for that certification. It's the same type of certification that you would give under Part 52 for Court of Appeal appeals. You will put a court heading on. You'll say that it's a certification under PD 45A, paragraph 15.1 in the tramlines, and then give the simple statement certifying as required in the practice direction and sign it. I've given you the deadlines on the slide because of time. I'm not going to go through them all, but just bear in mind that for formatting, hard copies, I mean, this is pretty standard stuff, but need to be in a lever arch file. The references and the parties need to be named on the spine. The documents must be legible, and the bundle must be double-sided. In terms of soft copies, there is a whole host of requirements for making soft copy bundles. There is, in fact, an administrative court guidance document on it that I would suggest you have reference to before you're making a soft copy bundle. In terms of the contents of hearing bundle, again, only include relevant documents. Judges really hate it when there's a lot of irrelevant documents in there, or sometimes, and I'm sure I was guilty of this myself in the past, when you've been running a case from start to finish and you know that your client is potentially quite litigious, you will put in more documents than is strictly necessary because you are slightly anxious about the client complaining if you miss a document. That's never going to change. If you can avoid doing it, do so, and try to discipline yourself to only include the relevant documents. A particular point that I think is helpful is in terms of correspondence. You do not need to fill a trial bundle up with loads and loads of letters back and forth between the parties. The exception to that, two exceptions to that, pre-action correspondence that obviously should be included, and then any other correspondence that helps define the issues. What the court probably does not want to see, unless it's going to be relevant to a technical argument, is the cover letter serving things on the claimant, letters where you're threatening the claimant, telling them they need to withdraw their claim or you're going to go after them for costs. I mean, it's just not relevant to the issues. Obviously, the bundle should include the pleadings, the decision, and any relevant evidence. In terms of authorities bundles, they're not necessarily things that solicitors always have contact with, because typically they are left to counsel or, in some chambers, counsel's clerk to make the authorities bundles. There are a couple of rules that it's worth bearing in mind, though, because you should really be getting a copy of the authorities bundle yourself. It doesn't just need to go to the court, it needs to go to the other side, and you should certainly be requesting a copy yourself. Authorities bundles in judicial review claims are only allowed if you're producing one bundle to contain up to 10 authorities. If there are more than 10 authorities being relied upon, then in the same way for the hearing bundle, you have to do a core authorities bundle and a supplementary authorities bundle. One thing you may want to check is that the practice direction for the citation of authorities, and as I've put on the slide, you can find it by Googling it, has been followed. There are rules around the specific citations that have to go into the bundle of authorities. There are, as I suspect everyone will remember with joy from their law degree days, there is a hierarchy of law reports, and it is only the most persuasive law reports, effectively those with the full headnote, that should be going in the bundle. If there aren't headnoted authorities, then there's a hierarchy that you can follow. That, I think, is all I'm going to say on bundles. And Jim, I'll hand back to you to deal with the formalities of the day itself.
Thank you very much, Matt. So the substantive hearing, the big day's arrived and you're going into court. What can you expect? Well, it's at the discretion of the judge. If one party is unrepresented, for example, the judge may change the order in which he wants to hear from parties, but very typically it'll be the claimant who addresses the court first, followed by the defendant, followed by any interested party or intervener, a right of reply from the claimant, and then judgment. Whether you get judgment on the day or whether it's reserved will depend on the judge and largely how busy their list is, whether they have time to consider it within the listing time or whether they're going to need to go away and consider it more carefully, perhaps read some further authorities on the matter. Remedies. Judicial review must be used if you want a mandatory, prohibitory or quashing order. And that's set out in section 31 of the Senior Courts Act, 1981. A mandatory order, as you will know, compels a public body to act in a particular way. Prohibiting order stops the public body from doing something it has indicated it will do but has not yet done. And I've given the example there of the issue of a new education, health and care plan. And third of all, quashing, which means that the previous decision is no more, and it will generally be complemented by a direction remitting the matter to the public body decision maker, directing them to reach the decision afresh. There are a few examples where a court can replace the original decision with its own, but that's relatively rare. It's also worth noting at this point that section 29A(2) of the Senior Courts Act allows quashing orders to be conditional and not take effect until a specified date. That generally is to allow the public body to take certain steps, to have time to put in place whatever it's being ordered to do to make the necessary arrangements that it's required to do. But it's important with any of these remedies from judicial review to notice that they are discretionary. You'll see the case of Bahamas Hotel Maintenance from 2011 and Lord Walker's comment that all relief granted by way of judicial review is discretionary. The principles on which the court's discretion must be exercised take account of the needs of good public administration. And it's that last point that is front and centre, and I want to drill home. It's that good public administration is the linchpin of judicial review. That's why the court, for example, won't order a public body to do something that is impossible. Next slide, please. Thank you. So that's what you must use judicial review for. You may use it to obtain a declaration, an injunction, or financial settlement. So you've got CPR 54.32, which provides for that. But it's important to note a few things. So first, in relation to a declaration or an injunction, well, section 31.2 of the Senior Courts Act 1981 sets out the test for that, and I've put it on the slide there. I'm not going to read through it, but that's where it comes from, so I'm just making you aware of that. In relation to the declaration, finding of illegality will generally justify the court making a declaration. Usually that something was unlawful. But Lord Toulson in Hunt and North Somerset Council 2015 made very clear that in some circumstances, if one party doesn't want the declaration, the court can decide whether or not to put it in the order. The important point, and defendants will probably be aware of this, is that the court must, and it's not discretionary, it has to refuse to grant relief on an application for judicial review, and may not include a financial settlement award if it appears to the court highly likely that the outcome for the applicant would not have been substantially different if the conduct complained of had not occurred. So you've got to show a causal link, if you're the claimant, between the relief you want and the difference in outcome if the conduct hadn't occurred. Next slide, please. So after the court's dealt with remedy, it will then consider costs, which is often the area as lawyers we're perhaps most interested in if we've won the case for our client. And there's a few things I want to point out here. The starting point is section 51 of the Senior Courts Act, taken together with CPR 44, and it essentially has the effect of making costs the discretion of the court. And I give you a quote there from M and Croydon LBC 2012, which describes the matter of costs as highly fact sensitive and very much a matter for the discretion of the first instance tribunal. That, of course, is tempered by the general rule of CPR 44.22a that the unsuccessful party will be ordered to pay the costs of the successful party. Now, one exception to all of this is where legal aid's engaged, and very often in judicial review cases it is. And that's the costs protection that a party entitled to legal aid benefits from. The headline is that they're not automatically liable for costs. An application needs to be made for the assessment, and there's various hurdles the defendant needs to overcome if a legal aided claimant is going to be ordered to pay costs. Because of that, and I've included the wording there for your reference, the wording is typically that of the fourth bullet point. The claimant do pay the defendant's costs to be subject of detailed assessment if not agreed, and the determination of the amount of costs payable is postponed subject to an assessment under section 26(1) of the Legal Aid, Sentencing and Punishment of Offenders Act 2012. So if we go on to the next slide, and this really is spelling out what the case of Croydon really says. It gives you three types of cases. It's paragraph 60 to 63 that are the most pertinent. So you've got cases where the claimant's been wholly successful following a contested hearing or pursuant to settlement, and there at paragraph 61 you'll see that generally there it's hard to see why the claimant should not recover all his costs from the defendant. Then you've got case 2 where there's only partial success, whether that's following a hearing or otherwise. In that case, the court will normally determine questions such as how reasonable the claimant was in pursuing the unsuccessful claim, how important it was compared with the successful claim, because this is a mixed success circumstance, and how much the costs were increased as a result of the claimant pursuing the unsuccessful claim. So there the court will probably dive into the weeds somewhat, and the court will try to determine a reasonable settlement, taking into account the success and the costs that flow from the successful part of the claim. Third, where it's hard for the court to determine whether someone's been successful, that's often the case where it's a compromise or the case has become academic because of third-party actions, then the court has indicated that the default position will be no order as to costs. Both the claimant and the defendant pay their own. So that's the useful starting point. There's legion of further authorities dealing with the bespoke situations you might come across, but as a very broad rule of thumb, I suggest Croydon is a useful starting point for practitioners to consider. So that concludes this seminar in terms of substantive points we wanted to address. I hope it's been useful. One question that I see has been raised in the Q&A is whether a settlement can be in the order or in the form rather of a Tomlin order. Now, I've not come across a Tomlin order being used to settle a judicial review claim in my experience. I don't know whether Matt has, but I'll start with my preliminary view, and it is only preliminary. I'd want to look at this more carefully to give a formal view. But my instinct is that the court would want to dispose of the judicial review. Judicial review needs to be brought promptly, and it needs to be determined within a reasonable time to grant relief to the claimant, and also to be fair to the defendant. So staying a claim indefinitely, which is what a Tomlin order normally does, doesn't, in my view, fit particularly well with the regime of judicial review. But there's loads of ways that I can think of that you could achieve a similar result. You might agree, for example, the terms of relief. The defendant might make a promise to the claimant, but agree not to reflect it on the face of the order. And in those circumstances, the terms might not be a matter of public record. Claimants often also ask for anonymity, so that, again, their names are not the subject of public record. But generally, in my experience, claimants will want the defendant named and will want to see very openly that they've been vindicated. And it's particularly the case in judicial review. And there's a strong public interest in defendants being publicly named, so that there's public accountability. And going back to the linchpin of judicial review being the administration, the good administration of the state, I think in those circumstances, it's unlikely that I can think of many situations where a Tomlin order would be appropriate. So that's my 2 pence on that point, but I don't know if Matt has anything to add.
No, I mean, I've never seen a Tomlin order used, and the CPR does make provision for an agreed final order. So I suppose there's no reason in theory why that agreed final order couldn't be in the form of a Tomlin order, but I'm not quite sure how that would fit in with the statement justifying the reasons for settlement, etc., which would be a public document. So it's probably unlikely. I think just one other point to mention on costs, actually, if I may, is that from a defendant perspective, if the claimant is legally aided, I tend to advise defendants to proceed on the basis that they are simply not going to recover their costs, because it's so unlikely it will happen. There was a time, I mean, it's not used so much now for reasons that will become apparent with what I'm about to say, but there was a time when trying to get costs from a claimant who was legally aided in judicial review was called the football pools rule, effectively meaning that trying to get costs from a claimant in judicial review was only likely to happen if they won the football pools, i.e. they came into a very, very large sum of money. So I tend to think about it in that respect, that if you are a defendant, the claimant's legally aided, unless the claimant wins the lottery or something similar, you are extremely unlikely to get your costs. Yeah, but no, Tomlin orders, never seen it used in judicial review. I don't see in principle, I suppose, why it couldn't be, but I can also see why you probably would have a hard time justifying it, really.
Well, I think that concludes the only questions that I saw in the Q&A. So I don't see any more coming in, which I suppose just leaves it for us, Matthew, to thank the participants for coming to join us, to remind them that we'll be circulating an email with the details you flagged at the start. And
thank you very much, Jim. Thank you, everyone, for attending. We look forward to hopefully meeting some of you face to face soon.
Thanks, everyone.